Senator Brown, I think. Okay.
Colleagues, Honorable Brown, they have discussed it in the room now. We can't watch out there. I'm Jennifer Alexander Tatum. I represent Bowman County for the purpose of this hearing. I'm a member of the committees on judiciary and
I'm Darius Dillon. I represent Monserrato County, member of the Judiciary Committee for the purpose of this hearing.
The chairman?
Oh, that's myself? Oh. That's the chair of the Judicial Committee.
I'm Sir Joseph, for the purpose of this hearing, I'm a member of the committee on the NRC and the committee on business.
My name is Wellington G. Smith. I represent Middlesex County, chair of the Agricultural Committee, and for this, the purpose of this gathering, I'm a member of the Agricultural Committee. Also, this.
Ways, Means and Funds. Chair Glow Brown, Senator Maryland County, Ways, Means and Funds.
Senator Rankin County, Chair of Health.
I will chair, co-chair committee on Lands and Mines. Member on Concession Investment.
Who get it live war?
General
Who get it live war?
I'm Senator Boto County, representing the people of Buffalo County, co-chair on concession, member on mines,
Member agriculture, member everything.
So keep watching TN News on television. Then you may charge Cooper coming to you live from the chamber of the Library of the Senate as the Library of Senate for public hearing on the Salameta MDU. So we have here the Honorable Martina Kitangwe, Minister of Mines and Energy. We have representative from the National Investment Commission. Of course, we have the Acting Minister of Justice, Republic of Liberia. By the way, Martina Kitangwe is a former lawmaker from Nema County. He was appointed by President Joseph Boakai to replace Wilmot P., a former Minister of Mines and Energy. Senator Batiwa of Granku County chaired the committees on concession, mines and energy.
We want it to be very constructive. Senators, because of the importance of this discussion, will be given enough time to allow the IMCC members to convince them on the reason for which they want this agreement to be endorsed by the Liberian Senate. You, our guests, you are also welcome. You will be individually, by institution, making your presentation. The reason for which you want the Liberian Senate to rectify this agreement. By procedure, our press, the people in the gallery here, we don't cheer, we don't boo. If anybody behind there who is interested asking any question, please pass it to a senator. The senator can ask your question. But here, only senators are allowed to ask questions. Our guests, please, whenever a senator asks you a question, please allow the senator to pause before you begin to answer. And please answer to the point so that the discussion will not be too long. Again, you are all officially welcome. Thank you very much.
Thank you, Senator Batikwa, for the ground rules laid. At this point,
Oh, okay. Thank you, Mr. Chairman. My name is Nyandi Twain Jr., Senator of Nimba County, lead campaigner for consensual compliance in the Liberian Senate. Thank you.
Thank you, Senator Twain. So we ask the IMCC member to tell us the importance and the necessity of this amendment. So we ask the Minister of Mines to lead the discussion.
Minister of Mines and Energy, Matanaki Tungbe.
Statement from the Minister of Mines and Energy on the amendment number 3 to the agreement among the government of the Republic of Liberia and ArcelorMittal Liberia Holdings Limited and ArcelorMittal USA Liberia Holding LCC at the Honorable Senate public hearing January 21st, 2026. Honorable Chairman and members of the Senate's Joint Committee comprising the committees on lands and mines, construction and investment, judiciary, human rights, claims and petition, and ways, means, finance, and budget. This chair amendment to the Mineral Development Agreement between the government of Liberia and ArcelorMittal Liberia Limited is an instrument realized after years of tedious negotiations. These negotiations were guided by the national aspiration entrusted to the government negotiating team to ensure that Liberia receives its fair share of benefit from its natural resources. As a result, determined efforts were made by the government negotiators to enhance Liberia's benefit, not only from the mineral resources themselves, but also from the Nimba to Grand Bassel rail infrastructure. Significant strides were made to improve provisions in the existing MDA to strengthen the government of Liberia's oversight and compliance mechanism and to ensure that mining, rail, and port operations are properly aligned to deliver greater benefits to the Liberian people. Importantly, this amendment introduces a late penalty provision, which provides an additional compliance enforcement tool and ensure that termination of the MBA is no longer the sole remedy for failure to meet contractual obligations. Honorable Chairman and members of this joint committee, the mining sector remains a major driver of growth in the Liberian economy. It is therefore essential to ensure predictability in revenue generation, employment creation, and socio-economic development to support informed decision-making going forward. This amendment brings certainty to the investment framework under the MDA currently under review. With clearly defined milestone, it is now possible to project potential revenue from royalties resulting from increased iron ore production, processing, and shipping. By 2027, ArcelorMittal Liberia is expected to ship at least 50 million tons per annum And by 2031, shipment volumes are expected to reach at least 20 million tons per annum. This amendment establishes clear and enforceable mechanism governing shipment volume beyond 20 million tons per annum. These increased production and shipment levels are also expected to result in expanded employment opportunities for Liberians. Honorable Chairman and members of this joint committee, it may be recalled that during one of the legislature's oversight hearing last year, it was observed that the current MDA requires the concessionaires to appoint a Liberian to one of the top 3 management positions. However, the existing MDA failed to clearly define those positions, allowing the company to present an organigram with more than 10 senior management roles, thereby complicating enforcement of this provision. The proposed amendment addresses this deficiency by clearly identifying 4 executive management positions: Chief Executive Officer, Chief Operating Officer, Chief Financial Officer, and Chief Administrative Officer, at least one of which must be held by a qualified Liberian from and after the first anniversary of the Chair Amendment's effective date. Honorable Chairman and honorable members of the Joint Committee, the Community Development Funds has been increased by nearly 67% from $3 million to $5 million. Investment in education and public infrastructure have also been strengthened through commitments, including the construction of a new vocational training center in Grand Bassa County, among others. Over the years, it has been difficult, if not impossible, to ensure that the rail corridor from Ikepa to Bikena is available for use by more than one user. Although the existing MDA provides for third-party access, such access has never been realized due to limitation in the agreement's language. This amendment remedies that challenge by establishing, through the Rail System Operating Principle (RSOP) and related provision, a functional multi-user rail framework. This framework will unlock additional revenue opportunities for the government through third-party access and provide for a transition from the current user-operator model to an independent rail operator framework. Honorable Chairman and members of the Honorable Joint Committee, while the Interministerial Concessions Committee, RMCC, did not obtain everything it sought, an outcome that is common in any negotiation, the ministry firmly believes that the negotiating team has done its utmost to ensure that this amendment significantly improves the existing MDA and deliver greater and more sustainable benefit to the Republic of Liberia. Thank you for allowing me to make this presentation.
Voice of our Timber, the Minister.
Thank you very much.
Mines and Energy.
Thank you very much, Honorable Chairman and members of this joint committee, for the invitation extended to the National Investment Commission to form part of this hearing today. I bring you sincere greetings from my chairman, Honorable Jeff Legal, who have already sent his excuse for not being here today because he formed part of the government delegation for the World Economic Forum in Switzerland. And my executive director also happens to form part of the government's delegation to London for the arbitration case between the government of Liberia and Slow Mine. And I have already shared our presentation with the chairman of the committee and Senator Batukwa through the self-public also. So kindly permit me to read from the perspective of the National Investment Commission our presentation for the purpose of this year. This presentation summarizes the key fiscal, technical, and operational benefits expected to be realized by the government and key concessions made by the government in exchange of those benefits in connection with entering into the Third Amendment to the Mineral Development Agreement with ArcelorMittal Liberia. Benefit number one, one-time payment to the government. AML will make a one-time payment of $200 million in exchange for all the benefits it receives under the Third Amendment. This substantial payment can be viewed, among other things, as a net settlement for trade-offs made by the government in connection with modifications of the debt-to-equity covenant and other provisions that benefited AML. 2. Establishment of the process for transition to an independently operated multi-user rail system. AML has agreed to a process that is intended to result in the appointment of a new independent operator selected by the government through a public procurement process effective in September 2030. This has been a goal of the government for a number of years, and it is viewed as important by third-party users such as Ivan Buolani. AML will be appointed to serve as the rail operator on a non-discriminatory basis, on a no-profit and no-loss basis through the transition period. 3. Establishment of shipping milestones for AML with monetary penalties for non-compliance. AML has established milestones for attaining shipping volumes of 15 million metric tons per annum by December 31st of 2027, 20 million metric tons by December 21st of 2031, and 30 million metric tons per annum by a date to be established within 36 months of effectiveness based on an engineering study to be presented by AML. There are escalating monetary penalties as the sole remedy of the government for AML's failure to achieve these milestones. These provisions are intended to address the holistic failures of AML to meet its production milestones and the lack of any remedy for the government other than to terminate the MDA for material non-performance. The government has found this penalty too draconian to exercise. 4. Process established for AML to lease its unused railroad capacity to other users on a temporary basis. This should enable users to gain access to the railroad earlier than they otherwise could if they needed to finish capacity expansions for their own needs first. This may also prove useful for small shippers. The government will receive 30% of the net profit realized by AML on any leases of unused capacity. 5. Process established for identifying land within AML concession area for use by third parties for stockpiling and loading and unloading facilities. The process is an important step because AML to date has been reluctant to enter into discussions that will enable third parties to build the infrastructure they will need in order to gain access to the railroad. Further agreements will be required once land is identified. 6. AML expansion rights on the railroad documented. The rights of AML to expand capacity for its own use up to 30 millimetric tons per annum by December 2030, subject to a 1-year extension for substantial completion by that date, is recognized. If AML does not complete the project by that time, other users can begin their expansion projects. AML is granted a further right to expand up to 45 millimetric tons per annum if it can demonstrate need and will commit to use at least 80% of the new capacity within 7 years. There are monetary penalties if it fails to complete the expansion within 3 years or to fulfill the usage commitment. Although this can also be seen as largely a benefit to AML, it is beneficial to the government to have the rights documented and the conditions on which AML can exercise the rights spelled out. This also provides more certainty, enabling other users to plan their projects. Social welfare benefits. AML agrees to develop and implement a social infrastructure plan that addresses concerns expressed by the affected communities in Nimba, Bone, and Grand Bassa counties, respectively. The Third Amendment includes specific projects. There are special monetary penalties benefiting the Community Development Fund if the timing and funding requirements for this plan are not met. AML will contribute US $5 million annually into the Community Development Fund. At least 50% of the annual contribution will be earmarked for investment in communities within the concession area and the remaining in adjacent communities in the affected counties. The Third Amendment creates a process for developing a government mechanism that is responsive to local development agendas. The management employment milestones have been updated since AML had not complied with the existing milestones. Other fiscal benefits and trade-offs. In general, the parties modified some minor fiscal items and extended many of the stabilized tax terms for the existing MDA for the next 25 years. The government made trade-offs on some major fiscal items which, if accepted by AML or enforced by the government, who have meaningfully increased the government revenue from the project in exchange for the one-time AML payment and AML's agreement not on the real estate. Income taxation. The Third Amendment extends the concessionaire 25% corporate income tax rate for AML instead of the statutory 30%. Debt to equity ratio. It is the government's view that AML has been in long-standing and material default under the 3-to-1 debt to equity ratio under the existing MDA provision. This default has serious implications for the revenue of the government's 15% equity stake in AML. AML disputed whether it was in default. The Third Amendment essentially eliminates AML past default and gives it wide latitude for using debt financing going forward by eliminating most of the effect of accumulated losses from the definition of equity and purposes of the MDA. Annual surface rental payable by AML changed from a fixed rate of 300,000 to a rate payable under the money pool and revenue pool. Annual payments by AML under the MDA have been indexed for inflation. Late penalties imposed. A schedule for monetary penalties is established for failure to take actions by deadlines under the MDA, in addition to penalties described elsewhere. This provides the government with a remedy short of termination for these defaults. Put a Buchanan operating framework document. The third amendment does not make any significant changes in AML's put operations, but it does provide for more detailed documentation of those operational procedures through the put operations agreement to be entered into between the National Port Authority and AML. Establishment of more detailed process for third-party access to the railroad and capacity expansion on railroad. This was a key objective of the government from the outset. The RSOP spells out in detail the process of new users to apply for and be granted access rights to use the railroad and expand the capacity of the railroad to meet their needs. The government has sole description of approval to approve access and capacity expansions, with input from the Joint Management Committee comprised of users. Establishment of procedure for selection and appointment of independent rail operator. The RSOP spells out the process by which the GOL will select and appoint an independent rail operator through the public procurement process. The selection is made solely by the government based on qualification criteria established in the RSOP. Establishes rights and duties of users on the road.
You got 1 minute to summarize.
So provides let me just go to the right. So under the RSOP, what protects the government's interest under the protection of the government interest under the RSOP requires government approval of any amendments to the RSOP. Require government approval of certain policy decisions by the Joint Management Committee. Government, through its non-voting membership on the JMC, can initiate proposals at the JMC. Government members will act as chair of the JMC meetings. So, honorable senators, honorable chairman, and distinguished members, in summary, the Interministerial Concession Committee has negotiated this concession in good faith, fully cognizant of the needs of the Nigerian people. As such, I submit on behalf of Chairman Jeff Bleeding. Thank you.
Thank you. Honorable Chair. Honorable Chair, a distinguished member of this committee. As you are aware, the Ministry of Labor is charged with responsibility to administer the affairs of labor in the Republic of Liberia. For the purpose of this hearing, we will highlight key points in this third amendment that the country and the people of Liberia, including those who are from in the affected community, stand to benefit
if it is ratified by you, which by God's will we know you will do, because it's all in the interest of every one of us. Within this amendment, it provides some of the benefits that you will see in the amendment includes job and liberalization management. Under job and liberalization management, the amendment provides that within 1 year of ratification, at least 50% of the job that will be provided by AML will be given to Liberians. It also provides that within 1 year of the ratification, if that is done, at least one of the top 4 managerial positions, which include the CEO, CAO, the CFO, and COO, will be occupied by Liberians. It also provides that absolute preference will be given to Liberians in terms of job that Liberians are capable to do if that vacancy exists. That means the inflow of foreign nationals that we all continue to complain from, the graduating from, bringing people from out of country to come and do the job that Liberians are supposed to do. So this provision also stands to benefit all Liberians if this amendment is ratified. You will also see in the amendment that there will be technical and vocational training school constructed in Grand Bassa County. It also provides for giving support to people from the affected communities. I mean, Lima, Bassa, and Grand Bassa County. Residents of those affected communities, the amendment provides that if it is ratified, there will be priority given to them to train them to become geologists and mining engineers, since their focus is in those directions. So that means the affected community that have been crying all the time, they will now stand to benefit if the amendment is ratified by this body. Again, the reason why we from the end of labor, we feel it is necessary for this body, the honorable body, to ratify this amendment is that our citizens continue to cry for a job. They come in to be a vocational training school. The fact that the amendment provides that there will be opportunity for Nigerians to go abroad and learn. There will be opportunity to sponsor people from the affected community annually to go out and acquire knowledge to come back. It means they are graduating from importing foreign nationals to come and take lucrative salaries and benefits that they carry out there and develop their own area, but now will be training our people who will be capacitated to enjoy any proceeds from any proceeds from that will remain right in country and will develop our economy. Honorable Chair, a member of this body, I am pleased to let you know that the summary of my presentation has ended, but this is my recommendation. I will recommend that while it's true that this agreement is very much in the interest of the country, as you all are aware, we also, on the list of collaboration, will also depend on you upon ratification, the team will continue to work together. Your oversight should be with us as implementing agency and institution to make sure whatever existing or I place this amendment can come to fulfillment so the people of Liberia can benefit. But all the amendment is good and we're quite sure that you will work to rectify. Thank you.
Thank you for your presentation. Now listening to you. You are legal ministry, you come for you. So we ask Sergeant to make it commitment so it gives you more come. You make it commitment to report abroad. There will be time for function. When you get this,
Anthony G. Myers, Deputy Minister of Finance for Fiscal Affairs.
Do hereby swear.
Do hereby swear.
That the testimony I am about to give.
That the testimony I am about to give.
And to my recollection.
And to my recollection.
Is the truth.
Is the truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
Yes, sir. Witness is qualified, sir.
Thank you.
Mr. Chair? Yeah. Our guests from the executive have given us a very beautiful speeches on our board. Can we get a copy of these speeches so that we can form part of our oversight for compliance later?
You brought copy of your speeches?
Yes,
sir.
sir.
Yeah, you and us.
All of those who made presentation, do you have them soft copy or hard copy for our file for future reference for oversight?
Yes, sir. Yes.
Okay, so please send it to the chair.
We've already submitted.
Thank you. I'll submit my soft copy to the chair, sir.
Every minister, out your time. Keep writing time.
Thank you very much, Honorable Chairman, and my apologies to the committee and the Senate for not being here from the start because I didn't know the communication was routed through our IMCC chairman. I just saw it when one of the officials here called me, so my apologies again. So I'll sit in for the Minister of Finance, and I'm the acting minister because he's away on national duties in Switzerland. And the Minister of Finance is an integral statutory member of the IMCC. And the Minister of Finance was also fully involved with the negotiation with ArcelorMittal Liberia. And one of the most intense part of the negotiation towards the end happened to be the fiscal provisions. The Ministry of Finance, assisted and supported by the Liberia Revenue Authority, was interested in ensuring that the fiscal provisions in the proposed third amendment mark significant improvements on all previous amendments, including the existing one that is due to expire in 2030. So, even before Honorable Dillon made the request, I've already flashed the document I'm about to read from to some of the members whose number I had. That includes Senator Tyler, Senator Twine, one other person. So I hope you can please extend my hand in that regard.
Please send it to the chairman.
Okay, then I will get a chairman's number and then send it. Okay, thank you very much, Senator. Okay, so the summary here provides a series of revenue provisions from the Liberian Revenue Code. And what were the changes made in the proposed amendment compared to the existing one? So I begin with income tax, corporate income tax. Under the Revenue Code, the minimum concession you can grant to concessions emitter is to lower the rate from 30% to 25%. So that has been in existence, and also in 2024 we introduced the amendment to the corporate income tax for concession, money agricultural concessions, which require them to pay 2% of their gross revenue in advance on the quarterly basis while waiting for the end of year or tax analysis or income and profit analysis. So they were subject to the 25%, but not the 2% presumptive. So as a result, we had to wait to the end of the year for profit to be declared before we can tax. So under the new regime, the 25% were retained as part of the negotiation, but the 2% minimum tax was introduced. A presumptive tax was introduced. But more than that, we also introduced what we call a high yield surtax, and that's about 5% of the corporate income tax. Meaning, in the event where iron ore prices go above what we projected along with AML at the beginning of the year, when the actual prices during the year exceed that, that is considered super profits or windfall revenue. So that windfall revenue will therefore push the tax rate now to 30%, which means an additional 5% will be levied. In addition to 2% on the excess, on the margin. Say price was projected at $100, iron ore price goes to $150. 2% of that $50 will be taxed. Then the applicable tax rate for that year will be 30% instead of the negotiated 25%. Then interest deduction. Under the current regime, meter can deduct 50% of their interest from gross revenue or the earnings before tax and interest deduction. So what that does is that the base profit or the base revenue that is subject to taxation is reduced. So under the new arrangement, in fact, the revenue code requires 20%. So through the negotiation, we settle on 25% instead of the current 50% of interest deduction that is applied. So what that means is that more resources are left for tax purposes. Instead of 50%, interest deduction is now 25%. And then depreciation rate. As it is, all assets are depreciated on a straight line basis. But under the new arrangement, depreciation will go strictly by the revenue code requirement, where assets are distinguished between tangible fixed asset and other type of asset. And even among the categories of tangible fixed asset, the assets are depreciated on an asset by asset basis. For example, buildings and railroad track, for example, or installed plant, those are different type of assets, so they will be depreciated differently, rather than just a straight line and single roof for all type of assets. And then loss carry forward. The revenue code requires 7 years. 5 years, sorry, the new amendment requires 5 years. Negotiation, we actually pushed for the 5 years, but the negotiated rate is now, carry forward period is now 7 years. And this was merely in consideration of the type of industry. the type of industry, because this is where heavy equipment are involved, the period between acquisition of those assets, installation, and putting into production, it takes significant time before actual production can happen on a given borrowing. So we're flexible in that regard by carrying it from 5 years as is the code to 7 years. Then royalty. One of the main issues that have bothered all policymakers has been why meter has not been declaring. Okay, no, sorry, this is royalty. So the current royalty rate is 2 to 3% based on what is discussed. The revenue code say 4.5%, and so the new proposed amendment went by the revenue code requirement of 4%. And the payment initially was done at 45 days after shipment, or 45 days after the end of the quarter in which the royalty is due. But this time, it starts to shipment 30 days after the date of shipment. So if it shipped today, January 21st, February 20th, we expect the payments. And then there is a resource rent tax. The resource rent tax is pretty much in application in this agreement the same as a high yield tax, which is a 5% additional CRT during the year where there is a high yield. Surface rental. The revenue code in section 704 have various provisions for surface rental. There is 20% per acre for exploration, $5 per acre for license for the first 1 to 10 years, and then $10 per acre for license contract from 11 to 25 years. So meaning the 25-year period of this agreement, the surface rental will be staggered. If meter is to go into any new exploration in any of the part of the concession area or anywhere else, that would be the staggering of it. The first part for exploration only, it will be 20 cents per acre. Then for 1 to 10 years, that will be $5 per acre, and then after 10 years, that's $10. Import duties. I will speak more to import duties as a separate thing from this, so let's skip that. Then custom user fees. Yes, they are subject to the 1.5% of CRF value at all Liberian ports. This was not included explicitly at that because it was just capped at $10,000 per item, but now it's 1.5% of CRF value. Then GST, as it is, they were exempted from GST, but right now they will be subject to all GST or all items as required by the LRC, except those things that were exempted specifically in the concession agreement. Dividend, okay, I was talking about dividend earlier. So as it is, there is no provision for dividend in the current agreement, but the new agreement, proposed agreement, requires for AML itself 3.5% of dividend on their profit. Third parties, other than the government and GOL, other than the government and AML will be 5%. So 3% royalty charged to AML profit, and of dividends, then 5% on other third-party dividends. And this argument, we put it because dividend is an income that is earned in Liberia. So our law requires that any income earned in the country should be subject to income taxation. Interest, 5%, the current agreement says 5%. Now this is for the distinction between resident and non-resident in our code as to what interest can be charged on certain services. So the law now say 5% for residents, so Meter Liberia be a resident. But this doesn't apply to Meter holdings, that means other affiliates outside of Liberia, but it's only ASLOC Meter Liberia. And then services. We know ASLOC Meter procure services from many sources, domestic and external. So under our new provisions, 6% for service providers, we have to do withholding of 6% or whatever fees they pay to service providers. The capital structure. The capital structure, meaning how much of debt compared to overall equity we accept, is 3 to 1. As it is, there is no specific provision. In our negotiation, Meter was proposing 4 to 1. We say no, 4 to 1 will mean that greater interest deduction on debt, which will depress our available revenue. So the debt to equity ratio negotiated in this contract is 3 to 1. And I'm sure if the Ministry of Internal Affairs, of Mines and Energy are presented, there was an increase in the Social Development Fund from 3 to 5 million. And I was talking earlier about the custom provisions. As attachment 5 to the agreement, there's a list of more than 20, up to 25 items that are subject to import duty adjustment, in some cases waivers. But one significant change we made this time is that all of the items included on the list of adjustment or waiver are investment related, things that will be needed as part of the build-up process, not items that are brought for regular use, whether by employees or management or others. So a typical example is on number 18. Education supplies is included as materials for custom duty exemption or negotiation, but we excluded stationery. So what this means is that stationery as an indication or process for the kind of commodities that they had exemption on in the past, like toiletries and those regular things we find in our merchandise, will no longer be subject to duty waiver. And we also included further in this discussion, in the negotiation, it will also be seen is that there were provisions, it's not in my note, but it's like we are referencing the contract, that the first port of call for energy use for Meter will be our public grid. To the extent that wherever they are operating, whether in Nimba, Bong, or Buchanan, to the extent that there is available capacity on the public grid, Meter will be required to use that as a first port of call. Then they are not prevented from doing self-generation, but where there is capacity on the public grid, it will be required to buy from the public service provider. So those are just some of the improvements we made in the fiscal and other provisions. So with that, Honorable Chairman, I submit.
Okay. We were going to refer to the justice. Oh, okay. So justice, please take a stand.
Honorable Chair and members of this honorable committee, much has been said. I would not want to bore you with additional information. Justice Ministry just took cognizance of the fact of Article 3, Section 2, which require that the terms should be fair and reasonable. And we think from everything that has been said, the new amendments that are made to this agreement we consider them to be fair and reasonable for Liberia. And so at this stage, I will submit, and we'll look forward to any legal questions that we need to answer.
Okay.
So, last shot by the Ministry of Justice. So, all of the justices
So just a question, I'd like to know from members of ICC, during the period that AML has mined, what's the quantity of gold that has been mined? That's one. What has been the cost of the investment? And then how much revenue has been generated?
Anybody who wants to answer?
Got any information you can get out there?
No.
Honorable Chairman and distinguished member, with respect to the question as it relates to the quantity of oil being mined since ArcelorMittal started lifting oil, the data is there, but we don't have the exact figure yet, but we'll furnish the committee with this, before the end of the day.
Do you also have an idea on investment up to this point? So there are two questions. The total investment, only for whole mine, and exported, and how much has been generated for what it's exported.
So, I'm sure for us, the information is available, but it's not readily at hand. Because
It's not readily available.
No, it's available on Verifast, but I mean readily at hand in here. Because you won't, this is not something you can guess.
So it's not readily available.
Okay.
So you can furnish the committee with the information?
Yeah.
No, we have to So, Senator Jalal.
Just one question. The first one is an observation. Usually on an agreement like this, we will have amendment and restatement so that we have the picture of the whole agreement. Unlike yours, you just send us an amendment. What happened to the rest of the agreement? How are we going to monitor the rest of the agreement? Are we going to be having two separate agreements? That's the first question. I have the other two questions if you answer these.
Thank you, Honorable Senator. With reference to the amendment, as you know, the agreement was first signed in 2005. And two separate amendments have been made. Those amendments were made without restating the entire document. So we believe that it is along the same line that this third amendment was made. So normally what we do is to have an unofficial version that blends the changes made in the agreement versus those specific parts of the agreement that are not amended. Yes, sir.
Unfortunately, this is unacceptable because 10 years ago is not 10 years later. I was not here 10 years ago. We have a modernization in drafting laws. This is a law that we're drafting and it's an agreement. So that's more reason why, you know, why you did it last time, you should recapture everything to give us a direction into the future. Right now, we don't even know what you agree on, what you have been doing. How do we monitor all of that? So there's a need to have some understanding on this, that you will recapture, have an amendment and restatement of this law. That's my first question. I'll leave that to the decision of the Senate. My second question, how long is the contract, this concession? How long did you allude to automatic renewal at the expiration of this? Are you alluding to automatic renewal?
Honorable Senator, the original provision that is made for the contract is that the concessionaire shall have the option for an extension, 25 years extension. So as this initial one is ending in 2030, they are exercising our rights for additional 25 years.
Yeah, but you're subject to terms and conditions. You're not busy there. At the end of this period, you're subject to terms and conditions. So it should not be automatic. Am I correct?
It's unfortunately it's almost automatic. So the only term that is provided for is that they should have a showing or from the feasibility report that there is additional iron ore in the ground.
That's my next question I'm coming to. But there should be no automaticity in contract agreement, because there could be something very miraculous that will happen. Supposedly you find that the price of iron ore has doubled or tripled, for which reason why you may want to add some, information to that agreement. You're just going to say it's automatically reviewed. So that is also unacceptable. Let me ask you my last question. I know you have decided on these things already before coming here. Now let me ask you my third question. My third question is, and my last question. How many medical deposits in this demand margin? How much has been exploited so far at the time of extending this contract? And how much will be there when it's automatically renewed? Do you have that analysis?
Honorable Senator, the analysis is available because the amendment is contingent upon that analysis. Because what is stated is that before an extension is done for the contract, there should be a feasibility report. Right. And the feasibility report will state that there is additional iron ore there, which is the amendment is contingent upon. Unfortunately, we cannot readily make it available now. He's just about to make it available. Yeah, he's just about to make it available.
Thank you, Honorable Senator. As a basis for the discussion, and this discussion of the amendment started 7 years ago. The former Minister of Mines in 2019 approved a feasibility that was submitted by ArcelorMittal with the following characteristics of dry metric tons. Tokade, Gangra, and Yellowton indicated was 689,489 million. 689,489,000. And then on the inferred was 1.9 billion, totaling to more than 2.6 billion tons of iron ore.
No.
That's the resource.
That was there.
That was there.
2019.
Yes. And if
that assessment was done by ArcelorMittal.
Yeah, it's done normally by an independent group, because normally these groups that will do this sort of investigation, it is based on such information that investments are made. So you have third parties that have specific legal obligation to ensure that the data that they present are genuine and individuals can invest in such activity.
So, Mr. Chairman, please follow up. So, according to that report, who was the independent group that did that assessment?
I'll be able to get back to you before the end of the day, because I knew we would definitely have the figure in terms of volume, but I can give you that before we leave.
Were you reading the report?
The specific section. I'll just give that to you before we leave.
Yeah. Okay, so now you have the floor.
Thank you. Thank you. Distinguished gentlemen, I have the floor. Just for 10 minutes.
I think we'll be having ample time. We can force to finish today.
Thank you, Mr. Chairman, and to our witnesses on the stand. Let me welcome you again. I sat here and listened to some of the presentations that clearly articulated the views of the executive, some of which were full of admiration and praise for the agreement or the proposed amendment. I want to use the first half of my time to just lay out 4 key issues that we see wrong, and you take notes on that. It will be followed by our questions, and then you can respond. The first issue that we have with this entire third amendment is the issue where Senator Jala picked up from. You have proposed to us a 25-year amendment
Yeah, like I want to hold you a little bit now.
Yeah.
Senator Cyrus, I plead the case as well.
Thank you, Mr. Chairman. My name is Senator Cyrus. I'm representative of Beaufort County in the Liberal Senate. I'm member of the Senate leadership. So I have oversight over the security sector, that is defense, intelligence, security, and federal affairs. And I'm also a ranking member of the Ministry.
Thank you. Not that.
Oh yeah, not that.
No, I have to
Introduce myself.
Introduce the player cassette.
Yeah.
Mr. Chairman, distinguished senators, I'm Senator Prince K. Moy, the Senate Committee Chair on Ways, Means, Finance, and Budget, and the Legislative Caucus Head of Bond County. Thank you. Thank you. I hope this was not a clever tactic to take me off so that I can be back on point. But I will start from where I left. To the members of the IMCC, today you've given us a document to ratify for 25 years. But in essence, it is not 25 years. You've given us a document under the guise of 25 years for actually 15 years. Automatic, extension by 25 years, by 2050, will give the mountains in Nimba to ArcelorMittal for 75 years. But you are here today giving us a report that we are going to ratify this document for 25 years without legislative approval. The structure creates the possibility of even 100 years. That's what the document says, because from then onward, rollover will be dependent on good faith and feasibility study. So once Mita come and tells you, I will say, I want to continue another 25 years. And I think you should take note of that and respond appropriately. Without legislative ratification of these kind of documents, where will be our powers as legislators? The legislature will be surrounding all powers in totality to the executive branch of government to do the will of the people. And as the people's representative from Nimba County, I don't think that would be appropriate for the Senate to allow the clause to persist. The second issue of the four is the absence of termination clause and termination rights for non-performance. It is only in the agreement that failure to meet production, shaping, expansion, obligations, or even social benefits for a fragile community. The only thing that you will do to ArcelorMittal is to fine them. To the extent whereby those fines are spelled out. So what you will be doing now, people will be violating, people will be depriving our people of the social benefits and then pay smaller fines. Because to develop and spend money on our people will be much more expensive. So this is a clever attempt again. And if this clause came from the company to perpetuate our people in the kind of way they are doing, violating the current MD. And the reason this is important, and I will come there, we all are in agreement along with ArcelorMittal that they have violated the terms of the current MD, especially in terms of social benefits, hospitals, clinics, roads, etc. And so this is something that I want people to look at. You cannot have, this agreement does not meet the minimum standard of a renter and a landlord. No termination? No, that would be unacceptable. The third concern here, before moving to the question, will be the community infrastructure obligations are not enforceable. Why? Even as bad as it is, the current MDA that has been violated by ArcelorMittal has in Article 8 and Article 10 and other articles developmental and infrastructure benefits for the communities, for local communities, for affected communities. In the new and current amendment that you are proposing to us, they remove enforceable social benefits and obligations entirely. And then it stated, it replaced it to say 3 months after ratification, a social obligation and infrastructure plan will be made by the government and the company. And if they fail to do it for the first 3 months, they will pay fine. If they fail to do it for 1 year, they will pay fine. If they fail to do it for 3 years, they will pay fines. Are you reading? Are you seeing what I'm seeing? Why is the social infrastructure plan not an appendix or an addendum like the RSOP? You brought a real operating principle here, as an appendix to the agreement. What's wrong with making a social infrastructure plan and obligations and attach it to the agreement for us to ratify it so that we can know what the affected communities will be benefiting? This is one of the egregious omissions from this particular amendment that you are giving us. You've already violated all of the benefits that you should have given our people in the current MDA. And that's why we've been forcing up and down here. And they admitted it on oath what you said. And then you go and omit them again? No, that is unacceptable. And we need explanation for that. The fourth and the last one has to do with the flat lesson fee and fiscal imbalance. You wrote in the agreement and accepted from the that they will pay $500,000 as flat money fees. So the Jara was trying to touch it, but he didn't go for it. So we all don't know how to predict the future and the future of commodities or natural resources. Why this amount is not indexed based on production, based on pricing? By 2031 onward, all money lesson fees are replaced at a flat annual rate of $500,000. The fee is not indexed to production, it's not indexed to volume, it's not indexed to land area or inflation. So if ArcelorMittal goes on the money market today and take a $1 billion loan and decide that the entire concession area, all the money will be mined at the same time, yes, they can do that. They will pay $500,000. And within 10 years, the entire mines in Nima will be depleted because we'll be taking $500,000 without indexing it, without tying it to land mass, without tying it to volume. That is despicable, and we need clarification and explanation for that. Then I move to my questions so that you can just take note on, or if you forget to answer any one of them, I will remind you. Is there any document, by the way, to also show to us, given the egregious violations, we need to know who will hold responsible for our roads, the environmental pollution and all these things, the non-compliance in building schools and hospitals and clinics in the current MDA, because ArcelorMittal Switzerland AG that we've been operating with are sold or transfer all of their rights and liabilities, whatever it is, to ArcelorMittal USA LLC. Do you have document for that transfer? And does that document has in it an agreed liabilities, breaches, and violations that they are passing on to ArcelorMittal USA? Because many of us will go to court in the end. We are not going to sit here and people mine, in our area, dig big holes and leave us here, and then they think they will just walk away by bringing another agreement. No, it will cause us to go to court. We will go to court. So we need to know who to hold responsible. Say ArcelorMittal Switzerland has turned over to ArcelorMittal the USA. We need to know and see the document. And what's more worrying is that you should also answer me here. Who were you negotiating with IMCC? The agreement between ArcelorMittal AG and ArcelorMittal USA was signed on December 9, 2025. This MDA in Brian was signed on December 20, 2025. 11 days after the both companies did the transfer. So who were you negotiating with? Do you even know your new company that took over? These are things that we need answers to. There is no review clause as far as my knowledge and my readings are concerned within this agreement. And if it is there, please tell how is it? A representative called me last night and told me, oh no, you know, they didn't restate that because they need the old MDA. We are not going to be dealing with the old MDA as of 2031. Why this new agreement cannot have in it a review clause? People fought war and came to the Capitol building. Many of them were still rebels. When they passed the ArcelorMittal deal in 2005, guess what they did for us? They put a clause in there for us to review it. But here we are, democratically elected government with all the erudites. We are removing review clause from in an agreement to not give future government, legislators, president the chance to have a say in how the natural resources are mined in this country. Why can't we put it in this agreement? Is there a review clause? So that's it. Mr. Chairman, you've given me a lot of time. I know I raised a lot of questions. I will pause here for a while and listen to your input on some of these questions, and then I will make some follow-ups if there are time.
Can you please respond to the senator's concern?
So,
well, that's Senator Ian Twain of Nima County.
Senator, we will try to answer your question, all of us. And please remind us where we fail to answer any one of those questions. So we'll take them, all of them, not in the specific manner as you laid it out, but we'll try to answer them as much as we can. I would take the part with reference to the flat licensing fee, the mining licensing fee that we talked about. Okay? Now, the mining licensing fee in the current MDA is $50,000 US, one-time payment. And that is for 25 years. Meaning ArcelorMittal, over the period that they have operated, has been paying on an annual basis $2,000 US per year. And so for the 25 years, up to 2030, ArcelorMittal has had to pay only $50,000 US, one time, not every year. Under the current agreement, at the end of what agreement we have with them right now, by 2031, ArcelorMittal would then pay on an annual basis $500,000 US every year. So when we say within 3 years ArcelorMittal will finish all of the ore, we don't believe that's possible, because for the ore that is available in ground right now, if you were mining up to a maximum of 30 million tons, you will be more than 80 years. So yes, there are other taxes that are paid, but the mining licensing fee is not the only revenue that we get from ArcelorMittal. So that fee, in fact, ArcelorMittal will be one of the first companies that will be making that payment if we do not amend any of the other ones, or we do not have any new mineral development agreement. The rest of them that we have, they have stabilization clause, so even if we introduce $5 million US as the annual license fee, they will continue to pay what they have in the agreement as it stands right now. And I would just want to add that this amendment tries to amend specific section in the MDA. The MDA is the MDA as it is. Unless those specific part has been amended, it holds. So if there are termination clauses that are not amended by this specific provision, those termination clauses carry on. So it is only these parts that we have changed that are to be added to the new one. So as I said before, in the first amendment, 3 or 4 different sections were amended. It did not give us a new agreement. It is the same agreement, and only those specific sections that are being amended here that are going to apply. So there are review clauses in the agreement, and it calls for review every 5 years. Now, when it comes to amendment, what we already have is not a good agreement. What we have done is try to get the best out of what we have right now. And so in negotiation, it's always a give and take. We would have asked for everything, and the company asked for more. It was not only us. So we tried to get as much as we could get. The Minister of Finance laid that out, and our colleague would lay that out. So there are review clauses, there is review clause, there is termination clause, and the payment is not the only remedy. What we have done is, we gave, the agreement has been hard to enforce. We've tried. Some of those things were not enforceable because the first thing that you need to do is to give a notice of default. And it means if they do not cure that, you then go on to termination. It's like to tell your son, we'll kill you, I will kill you if you don't sweep. So that's the only, most of the time, that was a major remedy. And it's not easy for a minister to terminate an agreement that has jobs, that has revenue implications and everything. Or to terminate and then go to arbitration and keep the investment in a problematic manner. So we believe that some of the things that will help to enforce or ensure compliance is not to only have termination as the only remedy, but to have penalties. But yet, termination is still available on the table, and that has not been taken off.
Mr. Minister, I will interrupt you there because this is my time so that I can clarify something. This amendment is not just an amendment. It is enshrined in here that the MDA was going to be restated and consolidated. Yes, it reads. I will just start on page, page 2. It says, whereas the following series of negotiation and consultation, the government and ArcelorMittal have agreed to further amend certain provisions of the current MDA, which is the third amendment. Listen, we should get it right. It being understood that the parties have agreed to restate the current MDA in order to incorporate the third amendment herein and to enter into a full amended and restated MDA, incorporating all such changes into a consolidated document. We should have brought forward all of the, when you amend, that means the old MDA, the new MDA becomes a consolidated document. And this is not a restated and consolidated document. And this amendment after 2030 will be the new agreement. So what you did, you just took a few things from the old MDA that you were not satisfied at IMCC. Thanks to you for some of the improvement. Yes. But it didn't restate. Such an Article 8 that was clearly talking about roads and drainage and bridges and what have you, they were omitted. They were not restated yet. So this is my problem. So, you know, without further debate with you, I don't agree with you that clauses in the old NDA will still be used in 2031 in this NDA. They didn't restate them and they didn't consolidate them. You can go forward with another question.
In addition to what my colleague from the ministry was just explaining with respect to the flat license rate, there was a question raised that talks about because the volume of production has increased, So why should the fee still be like this? You know, fees, more especially the lesson fee, is not like royalty. That there will be an increment in fee with respect to the volume. But this is a fixed, lesson price that is being given on a specific time period, which is the 25-year period. Like he just explained about the $50,000 that was paid by ArcelorMittal. If we aggregate that, over the number of years, it will be $2,000 a year. There was no temper with it, but this agreement is saying that there should be an improvement on it. And this is the reason why every agreement is subject to an amendment, because it depends on the prevailing circumstances, under which the operation of that particular company is moving. So the issue of the license fee does not necessarily have to go along with volume.
My information here is that just to help the hearing, it is very important that the senator raised. And going forward down to the page 2, on the preamble of this document, it said the third amendment herein and to enter into a fully amended and restated MPA, incorporating all such changes into a consolidated document as soon as possible following the signature of the third amendment. The signature of the third amendment was obtained. It is following the ratification by the legislature. So before we ratify that agreement before us, that's the information. Thank you.
Honorable Chair.
You want to respond?
Yes.
Okay.
That was just one of the points that I was going to, that this is not a final. This is the amendment that we're discussing, and then it will be restated, consolidated, and made one document. So this is not a final. It will definitely be restated.
Are you saying after we ratify it?
It will be consolidated.
Wait, so we can get something clear. You said this is not the final document?
No, this is not the one for signing. His point is that we said we're going to all right, this is a third amendment. His point, as I understood it, is that why is the second why are the points in the second amendment not included? Why are they not?
But Minister Martin will come about this, so we can go and come back. But what are we ratifying?
I'm just honorable saying to him that his points are
No, that's my question. What are we ratifying? Now,
the third amendment.
you said this is not final.
Honorable, his point of the restating and consolidating will be done.
So we ratify, then we'll consolidate and sign it, approve it. Is that what we're getting from you?
So I think the point the senators that you are making is understood. So it's a case of, from my understanding, procedure and availability of information. Okay, Senator Jala, for example, mentioned that at the time of the first and second amendment, he was not here. And most people would say that. So if it's a appeal I'm making. If the situation is about having the previous amendment with us to compare what is here and there.
No, that's not the issue. What are we discussing now for possible or likely ratification with our vote?
Okay. The legislature had previously, in 2005, signed and ratified the MDA. Then that MDA went through 2 subsequent amendments.
That first period finished. Okay. And the second period coming in 2010, right?
I agree, Senator.
We're coming to ratify something that will take effect from 2031.
Is these changes that will take effect new?
So we're coming to ratify something that takes effect in 2031, when it's actually not before us yet.
No, okay, let me give you an example, Senator, with a provision that will be familiar with.
Okay.
The Constitution, for example. or the Liberian Revenue Code. Since 2006 and since 1986 and 2000 respectively, these documents have undergone several amendments.
No explanation, sir. This document will vote on it tomorrow. When does it take effect?
These changes, these changes are being introduced.
This document, the whole document, you brought it as third extension. If we, for instance, vote on it tomorrow, so we ratify it, when does it take effect?
No, you see, when you put it that way, it becomes difficult for us because there are some provisions. The MDA is still ongoing.
No, sir. Mr. Minister, we have an existing second extension until 2029, until 2030. It is not in dispute. It is upon which Aspen Meter is not already.
So, Senator,
this document you brought before us now.
Senator, the point I want to make is that amendment does not vitiate the entire document.
You listening to me too?
I was trying to respond. You not allowing me.
I'm allowing you.
Does not vitiate the document.
What we are not arguing or we are not agreement. Senator, this document is not about Aspen Meter current agreement. Senator, what I will ratify this on that Aspen Meter is not what it says in the agreement.
Senator, you don't have to accept my answer.
Senator, please. Let me. At the onset of this discussion, we said, let us talk one at a time. If the senator is asking a question, give the senator a chance to ask a question, then you respond. At the time the person is responding, you, the senator, if you call them to order, when they start, you say you report. If all of us engage each other, we will not understand each other. So sorry that the situation is this. So, Senator, are you satisfied with your concern?
No, so let me,
even though it's not your time.
Okay, so I'll wait from
you. Will wait for okay, so.
I know it's not my time and not to honor the floor. But we have to be fair to ourselves. We see something irregular. Trying, we are in government. It is a problem to fix it. We see problem and we're trying to dodge the problem. All of us can make this thing on the legal side. The documents say you want to consolidate everything in one. If you do so because of one side, just say it is a government. It's not to tear anybody down. You know what I'm saying? At the end of the day, we all want an agreement ratified. Let's not be good for the country. And so on. So it's irregular. There's a little problem there. Let's try to fix the problem. That's why you reach this point. So that we all come together and fix it. That's why we are in government.
Intervention sustained.
Okay. So let me go to the next one, the social infrastructure and social obligations. Why is it not in the agreement? Written credit, why is it not an addendum or an appendix to this agreement? Instead, it will be 3 months after ratification when they knew that they put their own RSOP there as an addendum or an appendix. Why? So our people should wait for the goodwill of the government and absolutely that in the future before knowing what in this document for them.
Please use the mic.
Honorable Senator, in answering the question that was posed by Senator Dillon, so if Article 7, which is on page 42, talks about, speaks about the social corporate responsibility of the concession to the people. It speaks about the $5 million that will be provided and ways in which the communities can benefit from this amount. If you look through If you look through A, all the way going down, it speaks about the amount that will be put into escrow account, the communities that will benefit, and so on. So it is not completely taken out.
This is a public hearing. Madam Minister, that was one of the meat that we're going to go through if you answer the social infrastructure question. If this is your answer, then we are learning even where I wanted us to learn. You are actually reducing the monies that you're giving to the county in the current MDA by $1 billion.
Yes.
Why is that? The current MDA gives $3.5 million to the 3 counties. This amended MDA is giving $5 million according to the increasing in MIU, we increasing volume, we increasing export, and you increasing about just $5 million. But that $5 million, you are actually just giving $1.5 million in addition. You divide it now into 2. You take $1 million that you used to give to the 3 counties without your intervention, and you say $2.5 billion will be used by you and the government through an established committee, leaving the 3 counties on expenditure down to $2.5 million. So you are reducing our benefits that we used to receive per annual to actually by $1 million. So what we are saying, in addition to in addition to all of these things, you were given the $3.5 million, but Article 8 and other article also suggested things that should be done. You cut all that up and you hit it on $1.5 million. Are you getting me? And that's why I'm concerned about the social obligations, because they say if they don't do it, you got nothing to do, then they will pay small fines.
Okay, so respond. Can I hear you respond to the senator? And senator, that's your last question.
Okay. In terms of the plan that we talked about, most of the time we tend to make decisions and plans for people without their intervention or without their input. And for that reason, some of our plans do not solve the problem that our people experience. And so the discussion between the government, which represent the people, provide that means by which input from the community can be taken into account to plan social interventions in the community. So it will not be left with the company alone or be left with individuals at the IMCC negotiating during that particular period to determine the best value to assist our people. And that's why there is an obligation and a time frame to come out with plans that will affect the community. That is the principal reason that we did not want to make plans for the community without even being able to talk to or listen to or have interventions from the community.
Mr. Minister,
in terms of
go ahead. But
in terms of the amount of $5 million increase from 3 to 5 million, I say sometimes we tend to benchmark 3 million on the initial MDA. The initial MDA had production target beyond what ArcelorMittal has normally shipped, between 3.8, 3.5, rarely shipping 5 million every year. It had obligation to ship up to 18 million tons. 18 million tons when the 3 million was injected into the current MDA. So an increase up to 5 million has now been negotiated. We wanted more. We wanted more. Now, when you come to the split, there is something called the fence line community. Those communities that are closer and those communities that experience the inconvenience of the mining activities. For instance, people in Buchanan will experience the noise of the train, just like in Bond County. People in the mining area in Tokade or Yellowton or nearby will experience the sound of the explosive. And these are the communities that will easily go and obstruct the activities of the company. And so the committee thought to say, look, through all of the networks that we have, all of the provisions that we have, the local government infrastructure, let's put half of this amount aside so that these people will receive specific attention from this amount of money. That money, that half of the fund of the $5 million is targeted specifically towards those that are in what we call the fence line community. Then the rest of that money is distributed to the rest of the county.
So I hope you right there. So the rest of it used to be how much?
2.5 million. No, initially it was 3 million to the county in general. Nothing specific to those that are in line.
I got you, and I commend you people for thinking about the fence line communities that are benefiting directly in this one. But you used to give 3 million directly to the counties. My point is you are now giving them 2.5. Let's agree on that you reduce it by a certain amount.
Yes.
And so all you're doing now, your production has increased. Your production has increased. So you only gave me $1.5 million in addition. There are certain facts that I want us to establish. I'm not trying to debate with you. I'm not trying to tell you that the money you should have negotiated for $20 million. But let's establish the fact. The monies that are going to the county now being reduced. The ones that you are adding up is just the amount of $1.5 million. How is it hard to agree with me? Okay. It's a fact. These are numbers. I can lie, you may lie, but numbers don't lie.
Can I come in?
Yeah.
Okay, so that's one way to look at it. But where is the $5 million US going to be spent? Is it not in the county? It's in the county. So the $5 million is going to be spent in the county, just like the $3 million that was spent before in the county. It is just the distribution of that amount in terms of that. So there is no reduction in the amount that goes to the county. The entire $5 million goes to the county, except that those that are closer to the mine and experience the noise and inconvenience will have that money being spent on them. So they are still members of the county. So if anyone leaves, for instance, some community far away from the mining area and come closer, they still benefit from that. So the total money is $5 million. It's for
time. Mr. Minister, let me correct you. Do you know about the 20%? No, I come in. This is misinformation. Let me correct it. Mr. Chairman, you give me a chance. There's a lot that has been said here. Mr. Minister, are you aware of the 20% that ArcelorMittal hired Africa to spend on our behalf? Do you know that money sat in the bank for 2 or 3 years, accruing to almost $4 million on spent money? They were accruing interest on it in a time deposit, and that interest didn't come to the county. Up to today, contractors are staying in the field, and that money is yet unspent. If you took that $2.5 million and put it on yourself again, and put it on AML and government wide committee, this is our fear. This is our fear. Yeah, I'm not blaming Vita for it.
Additional information. Additional information.
Can we answer this question?
Chair?
Mr. Minister, excuse me. Please, let me understand one another. The senators concerned, at the time the amount was 3.5.
3 million.
And 3 million. The affected county had exclusive authority to expend.
Exactly.
At the will. By project decided by them. But this time is split. And 50% of it can only be expended on the approval of AML. So that means we are saying yes. That's why you want to speak though. You want to speak though.
But that is not the situation. That is not what is written here. That is not what we negotiated. Let us take this step by step. Bomb River and Pastor State get here. Up to 2030, they get 3 million. After that, at this amendment, it goes up to 5 million. It goes up to 5 million. Now, when they say fenced land communities are defined clearly in Article 7A. They said the fenced land communities are towns and villages within within 1,000 meter, and they listed the county within 1,000 meter radius of the operating areas of meter.
Minister will read those things. We are aware of it. We read these things. I think we bring the questions up. So to go back and start reading to us is not okay. So the argument was properly just gave your reporter today, and we made progress on the next point. My thing is the reviews. My thing is the town has a significant portion in the implementation. Of the other hand, we shouldn't be so based upon my experience with the 20%.
Senator, we are all speaking to the Liberian people. We should also be given a chance to answer your question. The 5 million goes to the 3 counties. The fenced land communities are in the same 3 counties, not outside of the counties. Right? So the distribution, it addresses the issue of the 20% enrichment that was made between meter, AML, and internal affairs in 2020. Which some of us actually disagree with. In fact, in one of the hearings here, I specifically stated that that was a breach of the existing agreement. Because you can't buy to the legislature to do that amendment. Okay. So the purpose for which that enrichment was made was that the way the allocation and spending was happening in these counties, there were always issues. People were blocking railways. People were striking. Community members, including traditionalists, were moving into concession areas and bringing production to the state still. So these are provisions intended to ensure that those communities themselves become part of the decision and spending process. Okay. So the decision, the fenced land of the communities I refer to here will still be under the administrative and political structure that govern the county, which include county administration and county caucuses, except that this time, decisions on how to spend the money, what project to use them for, will be made in conjunction with the affected communities themselves.
Reminder of my remaining question for you. I'm giving it back to you. I just want to remind you. The question that has to do with the transfer document between the 2 AML and then the review clause. Those are the remaining 2 questions of mine that I need people to throw light on. The transfer document and liabilities between the 2 AMLs, and why is it that there's no review clause? Because this is not also a consolidated report. So I will not be clear to say the whole review stands.
Okay, so I thought you answered that question.
Senator, I just wanted to make further clarity, and the next question will be answered. Then the next question will be answered. You know, on the issue of the $5 million. Before then, this $3 million used to go to consolidated account. Even for the county to access their own money, it was a problem. But this time around, the money is going straight into the county's account. And the 50%, for instance, like the $3 million that were on the floor before, half of it goes to Niba County as a producing county. That $3 million, 1.5 million used to go to Niba County. It is out of that 1.5 now. Instead of 1.5, it's now $2.5 million out of the $5 million, 50%. Out of that 50%, it becomes now the $2.5 million becomes 100% for Nima County. Out of that 100 percent, which is 2.5, 50% of it goes into the community account directly. Then the half goes into the county account. It's not going to go into consolidated account anymore. That's it. So it's not a reduction.
Remember, you answered my last 2 questions.
All right. In terms of I know you disagree in terms of the provision for review, but obviously we hold the view that what applies is that there is always a 5 years review clause. A 5 years review clause by the NBA, but also provided for in the mineral and mining laws. So there's 5 years review clause for any NBA. And all NBA has a review clause. So we never alter and we did not alter that. In terms of change of control, what we're talking about is a change of control. A change of control needs government approval. Okay? So if parent companies have documents in terms of sale, obviously it will require government approval for change of control. So if we look at this amendment, there are specific entities that we're signing the agreement with. So as it relates to this agreement, the company that we are signing, the two entities between ArcelorMittal Holdings LC and what is it next? ArcelorMittal Switzerland AG. So these are the entities that we are signing with. So with reference to the question, I do not know what we stand to lose with reference to these companies, because we're going to hold these individuals that we are signing this specific amendment with and this specific contract with.
Mr. Chairman, to the witness, my concern has to do with the issue of the previous MTA with Vital had left 3 years. There have been numerous complaints and non-compliance posture by ArcelorMittal. Now you are ratifying, you brought an agreement that the previous one has not elapsed, and you bring in a new MTA to be signed. With those uncompliant activities that have to do with employment and other activities within the previous MTA, if the MTA that left 3 years elapsed and no responsibility that is strong in the MTA are not met, how do you compromise it entering the new MTA, which requires a new 25 years? So, for example, what I'm saying in nutshell is there is nothing there reflecting that whatsoever that was done in the remaining 3 years will be rolling over to the new agreement. That's a concern.
Whether the chairman and members of this committee, this particular amendment is associated with an expansion. That is not one, it's expansion, because we're talking about up to another 25 years. It's not this year plus another 25 years. It's not the remaining year plus another 25 years. This is an extension. And the extension, the law says that an MDA should not exceed 25 years. So the 3 years remaining, and you still want to extend, it is 25 years that we're going to stop. So we're not going to wait for the other year and say, oh, the remaining year added to this one. That's why we talk about extension. You are just extending the remaining year up to 25 years. And then another thing, I'm coming, Senator. Another thing that is there is that we're trying to make a better deal. What has happened in the past is what we're trying to improve now. This is the reason why we're doing all of these amendments. Because we want to improve. So, and again, putting some mechanism in place that those things that happened in the past, those violations, we're not going to wait until there is a violation, because the monitoring of this agreement, it also rests on ourselves, because in most instances there is some lukewarm attitude with respect to monitoring this thing. We want them to violate the concession, before we go there. This time we say without waiting. And this agreement is telling the company itself that you are starting to monitor yourself, because if you don't comply and there is a violation, you will pay a fine and you will also be monitoring yourself while we monitoring you as well.
The Deputy Minister answered my last question, but in the wrong way, not satisfactory. Chairman, the Deputy Minister answered the question and gave a wrong answer. I'm asking about the transfer between the two companies. He said the deal with the two companies and the agreement does not say so.
So, Senator Twine, your question was answered.
It was not answered properly.
You expect the people to answer your way.
No.
They answer and after you come back.
No, but this is it right here.
So what you
it said that ArcelorMittal Switzerland AG transfer all rights, entitlement, obligations, shareholdings, and the concession to ArcelorMittal USA. And they say the both of them operating together. And my question is, who were we negotiating with and where are the transfer documents? Because I need to know who to hold responsible in the future for the liabilities and the violations in my country.
So please answer to that.
Yeah.
Honorable Senator, the parties that we're going to the agreement with is on the top page.
I just read.
So you have to answer Senator Dillon. Yeah, Senator Dillon. Yeah, you have the floor. Thank you.
I just read the page. I see it's otherwise.
Thank you, Mr. Chairman. In 2022, the government of Liberia, through the executive, submitted to the legislature the entire extension of the ArcelorMittal mineral agreement. And the 54th legislature, of which I was a part as a senator, we did not agree with the entire agreement, not in rejection of ArcelorMittal as an investment company. But we did not agree, and we sent a request for extension back to the executive with concerns related to non-compliance. And that we are in 2026, and ArcelorMittal agreement or extension is back before us. I would like to ask some very pointed questions. Premise on compliance, especially for which we rejected or declined to extend ArcelorMittal in 2022. ArcelorMittal should construct medical facilities, provide education facilities and housing for their employees in the construction area and for people living in those areas. Is there any proof to show that ArcelorMittal has constructed medical facilities, provide educational facilities and housing for their employees in the concession areas? Question.
Thank you very much, Senator. Definitely, I mean, the MFDP may not be the most competent agency, but as member of the IMCC, we are unfortunate that the entity that could best answer that question, which is the National Bureau of Concessions, which does a monitoring of those things. Not here. So we take advisement and we will refer to them to ensure that they can provide those information. But
Mr. Chairman, no, without not taking note. The IMCC is comprised of these entities of government, including the NBC, correct? We'll take it that the IMCC has met separately, meaning in their several meetings, the NBC was in attendance. For the concerns that I just raised, considered in any of the IMCC meeting with the presence of NBC. Most times when we have people here, when we're asking for the entity and relevant institutions of government to be present, it is because we don't want one entity to say, oh, the responsibility is on the other entity in the land here. So no, we'll be showboating, we're just trying to do our work. Let me repeat, sir. In 2022, I led, and I don't let the we led the suspension or the rejection of the TER agreement because of non-compliance by ArcelorMittal. They're taking our own, but they're not doing. In fact, right now, I don't know, besides our beneficiary plant, ArcelorMittal built in Lima that is under construction because it's not completed. I think the only thing ArcelorMittal actually owned in this country since their operation was the train they had, because the bucket they inherited here from Lampo. So, has ArcelorMittal constructed a hospital in Lima, in Gambasa County? Have they provided housing? I'm not talking about continual rations. Have they provided housing for the employees? Education facility for the employees, the children of the employees, and community dwellers in the concession area. Question.
Senator
I will take it
Ibrahim
as we don't
Daros
have
Dillon
answer
of
to those
Masara
questions
County
right now, so we'll proceed.
posting his first question
Olaya
to
will
the
answer
team
tell where the hospital is.
as legislators debate on the Senator 13 here at the June
Where the
11th
schools
Senate.
are
My name is
constructed.
George Kobo, coming to you live from the
Yes, sir.
Chambers of 11th Senate.
Thank you very much for the question. And I think all of us share similar frustration when it comes to compliance, not only of the AML, but all other concessions in the country. And we at the IMCC, as we share those frustrations also, but we are also aware that taxes need to be raised, need to be collected, and we are then starting ready to negotiate those concessions. This is the reason why you see, the reason I'm raising the point is, I know that we're supposed to answer, but the point I want to make it requires a collective front. And I think one of the appearances of ArcelorMittal, I was here in questioning. So the effort to make ArcelorMittal and all other concessions to comply requires a collective front that we at the IMCC have taken serious note of it, and will revert to ensure that we play our part as we also kind of plead with the honorable Senate.
You see, police, the executive will take 1 year, 2 years to go through the negotiation. When you bring it here, we are supposed to pass it 1 week, or else the country will break down. You took more than 1 year or so to go through. In fact, we, this government, inherited this thing. We tabled it from the last government so that we can do it properly. I don't want a political speech because if I follow that political speech and we vote for this year like that, the public don't say that you did it. They say that the legislature and the senator, they don't want to vote for it. We don't have time. We don't do the negotiations. We don't sign these agreements. How can you give one president 25 years? 3 more years left. They are not constructed one hospital, and you only get another 25 years. So, no 1 minute, simply that political speech. I voted no in this chamber against the second agreement for B Martin for this same thing. How can I flip it now because of my own government? How do you expect me to flip it, my vote? Similarly, hospital construction, that physical, tangible asset you can see and touch. And you can't answer me not there. What is speech for?
Senator, the reason why I'm raising this concern is because we were asked similar questions in the lower house. And the reason why the NBC respond was just simple. In the next 5 years,
So there's no answer for this. That means no.
Sir.
I said, my senator speaking, did you change? Answer the question. That's no answer. And not answer why you need answer.
I have 2 more questions. So, unless later on, it can be proven or shown that medical facilities were constructed, educational facilities were constructed, and housing facilities constructed for the employees. Unless maybe later you can show that to me. When I was growing up, I was in Buchanan, Grand Bassa County, born there, grew up there, and Lampo used to be there. The security department of Lampo was part of the operation department of Lampo, meaning the security people at Lampo were employees of Lampo. That made them to benefit. In fact, there were new people that charged to do them because he was the head of the Plant Protection Force, resident in Nima County, in Yegepa. And I knew the Plant Protection Force, Grand Bassa County, or Lampo, they were employees of Lampo. Under Aslamita, the security department of Aslamita is also to private security to avoid medical benefit, leave benefit, insurance, and even retirement benefit. They outsource the job. The security department. Why is that so? Question.
Senator, thank you so much. Before coming to this question, I have certain reference I wanted to make, then I come to your question.
Please listen.
On the issue of the compliance issue, the compliance issue. Now, one of the reasons why we embedded clauses, because you know what happened in the past, those violations of the section, the non-compliance culture. And to correct those things becomes so difficult. So now that we come to this amendment, that's why we put in all of those clauses. That those things that happened in the past should not be repeated. You see that in Yekeba as it relates to the housing facility, the prefab out there, most of it have been demolished, and right now there are some renovations of those housing facilities that are going there. And some of the challenges we have there now, those are occupying their house. And you know, those houses, they are saying they should give them 2 years before they move. But the thing they ask on the time is also providing transportation to those who are prepared to move so that they can renovate those houses. They provide transportation to, you know, to move. But there is still that kind of non-compliance put up by community dwellers that are occupying those houses. But on the issue of those demolition is going.
Mr. Minister.
And then,
Mr. Minister.
Yeah.
You were a representative.
Yeah.
You said 2 terms?
One.
So you inherited the Aston Villa deal when you were here as a representative, correct?
Yeah.
In that deal, no compliance provision there.
Indeed, there is compliance provision, but the existence of the law does not suggest that violation cannot take place. That's why you need when council or policing, because you have police, it doesn't suggest that people will not commit crime. That's
right.
But
when people commit crime, when people commit crime, the law does not stop commission of crime. The law, no law can stop commission of crime. I care how harsh the punishment is. But when you commit crime, the law takes its course against you for committing the crime. That's what the law is for.
That one prevention is good.
Exactly, first.
Prevention, that's why in the document we're trying to put those preventive clauses
What
in there.
are preventive clauses?
The fact that before them, there was nothing in the document that tells us what we try to violate what we do. But this time around, if there's any violation, there's certain measures that will be taken.
What provision?
So, like the penalties.
What provision? Where is the provision in it?
Please.
Yeah.
It's there.
No.
So anyway,
that's here. So for education and information. They can help you inform.
There's a clause there called the late penalty provision. It's in there.
Late penalty.
Yeah. That is lateness in compliance. Okay.
Lateness of failure to.
I wouldn't call that a failure if there could be a delay and you will still queue that delay. That's why sometimes a default notice is given. So you can queue it.
Minister,
yeah.
My question is informed and deliberate. Late and failure are two different things.
That's what we're saying. Because if it is late, then we will not wait for failure. If you are late in doing that, we'll tell you to say.
Why you choose late compliance or failure to comply?
Because we don't want them to fail.
Then why didn't you inform?
So if you are late in compliance, we'll make you to correct your lateness. That's what we're talking about. So in making you to correct your lateness, there's penalty associated.
Lateness in compliance on what terms? What does it say?
Okay, can I just read it?
Yeah, please, sir.
Okay. Late penalty means an amount payable by the concessionaires to the government within 10 business days after demand by the government in accordance with and for the matter set out in paragraph G. Late penalties of Article XX specific undertakings of the concessionaire. The penalty triggered event. The amount payable shall be, as you just said, you see some there is 250. So this is just before then, all of these things were not spelled, and because if you make a law. Because if there is some strong penalty, sometimes to just go and commit crime, it becomes difficult.
That lateness to comply. Comply with what?
Comply with the provision within the MDA.
No, that was it.
What
you guys do? It's specific to a section.
Which section? And I just. That's
what I'm saying. The lateness to comply According to what? Read that again. Then you go to what is making reference to.
Chapter G. You go to G.
What chapter G is about?
Yeah, Senator.
We can read it in there.
Yeah, Senator.
Yes, sir.
Again, we already considered that all the existing documents need to be available. But where the minister is reading from, it made reference to chapter 20 of the MDA. Meaning there are provisions in the MDA for compliance at chapter 20, which, as he said, failure to comply or lateness in compliance has never been punished. So now this new amendment now is recommending
Chapter G, what is in chapter G about?
Chapter G of Article 20.
Yes, what is that about?
About all the areas for compliance, the compliance criteria.
Namely?
Yeah, unfortunately, we don't have it available. Again, the one I consider as a...
So because the reason I'm asking this question, because that failure, late penalty for, late penalty is specific to something. It's not about failure to comply and perform and deliver on all provisions.
Senator, I don't understand it that way. Every provision within the MDA, you should comply with it. So if any provision in the MDA there is an attempt or there is a violation or there is a delay in compliance, all of the provisions within the MDA are very
What
important.
does Section G reference for punishment for failure or late compliance?
Yeah, that's the reading I just wanted to go to.
Yeah, let's go to it.
So as soon as we get it back to you.
So you get it here.
They're trying to So another question that I wanted to ask,
you want
not to So we always play about the security issue where the security personnel are not directly employed by the company.
Yes.
See, there where we are again. We say empower Liberians, Liberian company. You contract this security firm to them, and they come and treat their own people like that. So if we go to the company again and tell the company, okay, take full control of it, we take Liberian out of the job again, then it becomes problematic. So there's need, maybe to put in place again. If you put this provision in place that all companies when you come in, you should have all of the facilities with you before you win a contract with the company. Then it becomes a kind of a strong measure we put in place to deny Liberian. That's the thing.
Put it the other way.
Yeah, which way?
Put it the other way. Put it the other way.
Which way?
Yes, sir. That is 1 more minute. Yeah, 1 more minute of that my last concern. Put it the other way. After meeting all companies in this country, if the security department is one of their operation department, meaning all the security at those places become employees of these companies. They will benefit from all rights pertaining to employment and employees. I won't see one company, it will put it in the agreement. I won't see one company that will bring non-Liberian, and I won't see our own Ministry of Labor, whoever the minister may be, giving work permit to non-Liberians for people to be private security, to be security at possession companies. I won't see it. So that cushion response you are giving general does not fly with me. No investment company is supposed to also the security department. Because to do that, while you empowering a Liberian private security company, you are also not you you are doing bad labor practice to those people because they are not employees of those companies, they don't benefit from housing, they don't benefit from insurance, they don't benefit from health, they don't benefit from leave.
Senator, we take
because of the one of time, I have many other things to go to ask, but for the one of time,
we take your advice, Senator.
Colleagues from the IMCC, I'll ask you questions. We'll start with the Ministry of Labor. Bang, yes, quick. You the Deputy Minister?
Yes, sir.
Mr. Minister? Yeah. How many additional jobs will be created as a result of this new amendment?
Senator, thanks for the question. When you look in the rural provision like within this amendment, you will see that the provision talks about a construction of new vocational school.
Hello,
Ask a simple question.
You know,
how many jobs will be created?
We will not be specific to tell you 300 jobs or 500 jobs will be created. I just want to give a little clarity so that the senator will understand that there will be a lot of jobs created. But we can't get specific number. Plenty job, as I explained earlier during my presentation. So if you allow me one chair, I think you get a clear understanding of what
I think I don't know for your answer, and Senator, you can proceed.
No, I would not because if you are negotiating, and you the labor minister, deputy labor minister, I think you are concerned. You can resolve all of the activities. How many jobs will be created? That will be part of your report. And you do not know the answer to disappointments. Because that's why you are part of the IMCC. Okay, so I don't know. But let's move on. Because I think you guys are going to be asking the Ministry of Finance. I understand, or we understand that Peter has made some investment in a concentrator plant. Is that true?
Yes, it is.
It was the result that was the volume that will be added now in terms of their production.
Well, upon completion of the plant, as was earlier envisaged, the processing of the material will be up to 15 million tons per annum of processed material. There are plans on the way to increase it beyond 15 to 20 million. Just to add, for clarity, the ore that is being shipped right now has not been processed, what we would say in common terms, washed, to increase the iron ore volume. So low-grade material will now be processed to enhance recovery and then increase volume. So yes, investment was made.
It's not finance. Do we know for sure what is the value of that concentrator? And now, we ask the question, with the other piece, in terms of how it's going to be treated, in terms of depreciation.
We were speaking approximate numbers and not being precise.
Okay.
In 2021, there about the announcement by Mita was that this expansion was to cost 800 million. But in our conversation with them over the past several months, they were now quoting numbers of up to 1.2 billion new investment. That is what they have told us. And I want to request. Now they concentrate on all investment, including railroad expansion and acquisition of new assets and others. And that is one of the reasons why they were asking for a higher debt to equity ratio of 4:1. We said, firstly, we want to see evidence of that amount of resources that you say you borrow. And secondly, what is the source of the financing? It says self-financing as the typical retained earnings you do in accounting where you use some of your earnings. Or if you borrow, they do borrow from another affiliate or you borrow on the market. Because all that will determine how we treat or how we accept your treatment of interest, deduction, and others. So these are the broad numbers that have been quoted. We are still asking them to give us the evidence.
You don't think that should have been part of the negotiation? Because if you are saying, asking them to give you evidence, they will go ahead and rectify it. And they complete that clear start. Do you think we'll be able to get the actual number in terms of how it's going to impact the fiscal side?
It should not, it will not, because that is what they are quoting. So even if we don't have the information from them now, when it comes to going through their books for tax purposes, the actual documents should be provided. For example, if you say, okay, you have an outstanding debt of say 100 million, and you want to deduct say the interest on that is say 50 million or 25 million, and as the provision in the law where you have to deduct 25% of your interest for that year, we got to see the evidence, the paper trail of the resources, the borrowing plan, and how you use the money. And then importantly, one of the key things we said here was that the interest deduction will only be applied to the portion of all borrowing or debt that were used for activities in Liberia, on the operations in Liberia. So thankfully the LRA has the capacity, both the auditing and legal capacity, to examine all of the relevant papers and ensure that we don't just follow what is announced, but actually documented evidence is available for determining that.
So you can say with certainty that in the absence of providing you evidence, at the end of the day, we'll be able to derive the actual number. What you saying now?
No, we will demand a document, but what I'm saying is that because your question specifically was why we don't have it and we're having this conversation.
Yeah.
And I said whether we have it now or later, it won't affect the tax processes. And so it will not affect the revenue that we are entitled to. Because before we accept their claim for interest or any other expenses, we have to see evidence of how those expenses were incurred. So the tax auditors are capable of ascertaining that. So anything that is not documented is discounted.
Thank you, Mr. Chairman, and thank you, Senator. Thank you, Senator Doko, for your understanding. I'm not going to stay long. Members of the IMC, Amendment number 3 to the Mineral Development Agreement among 1. The government of the Republic of Liberia and ArcelorMittal Liberia Holdings Limited and ArcelorMittal USA Liberian Holdings LLC in the presence of ArcelorMittal Liberia Limited. Question. Is there, and what is the difference between ArcelorMittal Liberia Holdings Limited and ArcelorMittal USA Liberia Holdings LLC?
What is called? What is exact? Yes. You got it
Can NICC or the sector magistrate answer this question, please?
Mr. Senator?
Yes, ma'am.
So I would like to refer to the page just after the cover page, this one. ArcelorMittal Liberia Holdings Limited, which was formerly Mittal Steel, is actually the concessionaire, and ArcelorMittal USA Holdings is the principal. So it's like a principal and agent situation. They're all operating on the same side as the concessionaires with Liberia on the other side. So the both of them are parties to this agreement.
Both of them are parties, but what I want to know, are they separate institutions, organizations, or companies?
They're legally separate.
Legally they are separate.
Yes. However, ArcelorMittal Holdings Limited is the one that is actually doing the operation in Liberia.
I asked this question when I'm Justice Minister. I asked this question. If you look at the signature page, which is on page 59 and page 60, the same two persons are standing for ArcelorMittal Liberia Holdings Limited, and the same individuals are signing this document with ArcelorMittal USA Liberia Holdings. That's why I'm asking the question. You are the legal person.
Yeah, there's a principle of principal and agent under the law, where the agent can take responsibility for the acts of the principal. Say, if the agent, like for example, he sends someone, the principal sends someone to go and do something civilly, the principal can take responsibility for whatever the person that he sends does. So even though they're legally separate, however, ArcelorMittal USA can also take some liability on behalf of the concessionaire in Liberia.
They are signing as the representatives of the two entities.
Yes.
So what I'm saying, I'm not talking about liabilities, but both of them are assuming ownership of the two entities. That's my point.
Well, they're legally intertwined in a way, again, as principal and agent. So if the agent is signing on behalf of the principal, it's really not an issue because if there are any liabilities, it's like the liability of one is the liability of the both of them.
Well, man, justice, I'll take it for that for the straight time we need to go ahead. Really, Mr. Chairman, and answer this part.
And additional reason for that would be ArcelorMittal Liberia is the one that is incorporated under our laws. Because this contract can be subject to dispute both internally and externally. So that when it comes to dispute on the provisions of this agreement and other Liberian laws, then ArcelorMittal Liberia Limited is the one that will manage that dispute with the government. But when the dispute has to go across the boundaries of Liberia, they take an international dimension. So in this case, ArcelorMittal's USA holding is an international vehicle that will then be involved in that conversation. Or it will be other transactions as well, not necessarily legal disputes.
Thank you, Mr. Army Minister. Let me move ahead, as I said. Let me come to you. You may not give it now, but I want to ask the chairman if you can have further information that we need to have it as per our records. How much has Liberia received in terms of royalties from August 17, 2025 to present? Let us know. How much has Liberia received in terms of royalties from this operation from August 17, the first day of the MDA to present?
August 17 or 1 year?
To 2005. 2005. Today. And then the president highlighted in his communication to the legislature about the expansion of the production. He highlighted the number of metric tons that will be accruing as one of the reasons why he wants us to pass this. So, Honorable Minister of Finance, I would like to know the expected from the expected expansion of production capacity. What will be the estimated expected royalties from this expansion? That will inform our decision.
Okay, so starting with the last question, royalty is 4% of 4.5% at Valorant, meaning whatever is the price, not the volume. Right. So when we can rely on Lens Amount when they give us a production schedule, we can make that available. Also going into the past as well, since 2005, the total amount of revenue we can. So we take note of that and we can supply that.
That's what I said. So let me go further. We're hearing our police from other places complaining about clients besides the affected counties. Is there any report from our own production that can tell us to what extent ArcelorMittal has complied with this MBA? Any report? Has the Liberian government done any studies that can show to what extent these people have complied with the MDA for which you want us to renew it? Question. Have we commissioned any report, any studies, and we have a report to say ArcelorMittal You have done this, but you failed in this one. You comply with this one, but this is where you fell short. Do we have any report of such?
Yeah. Honorable Senator, there's a report from the National Bureau of Concession. That report, I can remember, certain part of last year, we requested for 2005 all the way. But you see, the reason why I was trying to respond to the concern raised by Senator De Leon is because there was a time we requested a similar report from the NBC, and NBC explicitly told us the challenge they've been facing when it comes to budgeting, and they told us that I think for the last 5 years they've not been able to do a comprehensive compliance review, not only on AML but on other concessions. But I can tell you that NBC has done certain reports. We saw that report for 2005, I think up to either 2000, somewhere around there.
So you say, to the whole IGC, are you saying during your negotiation process, you did not take into consideration this report?
We saw the report.
So what did you discuss? Why did you negotiate with National Metal? Did you not point out to them that you brought new agreement before us? Amendment. Did you discuss with them their shortcomings on the old or the current MDA? Did you do that?
Your question is well placed. As the director of the National Investment Commission has said, in working with the NBC, we can also record that in July of last year, the legislature, both houses, both the Senate and both branches of the legislature, both the House and the Senate, also got involved in trying to measure the level of compliance of AML. And we all came to understand that AML was not compliant. This is no secret. And so, as a result of that non-compliant posture, we then talk about what remedies we can put in place from our side to sort of curtail some of the non-compliance issues. And that's why the minister talked about the late penalty. And the G, section G, if you look at that, it spells out 3 different areas which we have specific compliance mechanism for specific amounts that were set up. It excluded those, but the rest of those other default areas that we normally would have just served the company a default notice. They are not building a hospital, they are not building a road, or they are not providing a number of scholarships. You send a default notice and ask them to kill that default in 60 days. And if they do not kill that default in 60 days, that is the same provision provided for under the law. Then you have to terminate this agreement. We saw that as something too draconian for any minister to use. So it's difficult to then ensure compliance, because if the only tool or the most useful tool you have is to terminate this agreement, then you will have to consider, if I terminate this agreement, I will also be impacting jobs. I will also be impacting revenue. So let's put something short of that there. And that is why you see that is a new provision 20, which is XX, in the NDA that talks about penalties, late penalties, to sort of curtail some of these non-compliant, because they were not compliant at all. And it was frustrating to the entities to ensure compliance.
Thank you, my colleagues are impatient for me to go, so let me just.
I said last question.